Something has just changed in the long-running fight over the FBI records connected to President Bola Ahmed Tinubu. And this time, the story is not simply that the FBI is refusing to release the records. In fact, the FBI has now been allowed to take some of those records into court and explain privately to the judge why certain information should remain hidden. And that immediately raises a very important question. What exactly is inside these records that the FBI says cannot be explained publicly? Now, before we go any further, this is a very sensitive subject, so I want to handle it as carefully and factually as possible. There are facts in this story, there are claims being made by politicians and commentators, and there are also theories about what the latest court development could mean. Those three things are not the same. So in this video, I want to break the whole thing down in very simple terms. Who originally asked for these records? Why did the FBI refuse to release some of them? What exactly has the US court now allowed the FBI to do? So, does this mean the records are finally going to become public? And why has Atiku Abubakar suddenly entered the conversation so strongly? This is the reason why you need to stay with me to the end so as to get the full story from A to Z, because if you only read the headlines, you might think the US courts are simply ordered the FBI to release Tinubu's entire file. That is not what happened, and understanding that difference is where this story really begins. So, if I speak a little slower than usual in this video, please bear with me. You can always increase the playback speed if you want, but I want you to understand it. That is why I don't want to rush. Just do well to stay with me till the end. Make sure you subscribe and turn on your notifications so you don't miss next updates, and like this video. First, let's go back to the beginning. This current legal battle did not start with Atiku Abubakar. The underlying Freedom of Information Act case was filed in 2023 by an American transparency activist and researcher, Aaron Greenspan. He was seeking records from US government agencies relating to an old investigation connected to Bola Ahmed Tinubu, including FBI records and interview materials from the early 90s. The request involved records from agencies including the FBI and DEA, among others. And this is important because we are talking about events that go back more than 3 decades. The case became particularly significant because of the long-standing questions surrounding a 1993 civil forfeiture involving about $460,000 linked to Tinubu. But we have to be careful here. Tinubu was not criminally charged in that matter, and he has consistently described the matter as a civil forfeiture or settlement. So when we talk about these records, we are talking about records connected to an old investigation and allegations. We are not saying that a court has found Bola Tinubu guilty of drug trafficking. That distinction matters. Now, this is where the story becomes more complicated. The FBI has invoked exemptions under America's Freedom of Information Act to withhold certain information. And in its latest application, the FBI told the US District Court for the District of Columbia that releasing some of the information could reveal law enforcement techniques and procedures and could reasonably be expected to endanger the life or physical safety of an individual. So, in simple English, the FBI's argument is basically, there are parts of these records that we believe cannot safely be explained or released publicly. In fact, the agency went even further. It told the court that it could not put the full basis for some of those exemptions on the public record. Instead, it asked permission to explain those reasons privately to the judge. That is what the legal language, ex parte and in camera is about. In simple terms, the FBI wants to tell the judge something behind closed doors rather than publish the explanation for everybody to see. And that is the part that has generated so much attention, especially among Nigerians, because people are naturally asking, what exactly is the FBI trying to protect? Now, we have to be careful with that question because the FBI has not publicly said that the records prove Tinubu was an informant. It has not publicly said that Tinubu committed a crime. and it has not publicly confirmed the theories that have been circulating online about what may be contained in the records. What the FBI has actually said is that certain withheld information could expose investigative techniques and could potentially endanger someone's life or physical safety. That is the established part. Everything beyond that needs to be treated as interpretation. And this is another part many people may not know. This is not the first time Judge Beryl Howell has dealt with these records. Back in April 2025, the judge rejected the FBI and DEA's use of what is known as a global response. A global response essentially allows an agency to say, "We can neither confirm nor deny whether these records exist." But Judge Howell found that position difficult to accept in light of information the agencies had already acknowledged publicly about investigations relating to Tinubu. The court therefore required the agencies to search for and process the records and determine what could legally be released and what could still be withheld. So this has been going on for years, and that is why the latest development is significant. On August 20, the FBI went back to the court with a new application. The agency asked Judge Howell for permission to submit confidential declarations explaining why it should be allowed to withhold certain information. And now, the court has granted permission for that private review. This is where I want you to pay attention. The court did not say the FBI is right keeping everything secret. And the court did not simply say release the entire Tinubu file tomorrow. Instead, the judge has allowed the FBI to make its sensitive explanation privately to the court. The judge will then consider that information alongside the legal argument over whether the records or portion of them can be withheld under FOIA. So what happens next? The FBI, the DEA, the Department of Justice, and Tinubu's side have a deadline of August 28 to file their opposition to the release of the records. And according to the latest reporting, that means the legal fight is still ongoing. And the next major question is not simply, will Tinubu's files be released? The real question is, which parts can legally be released, and what reason will the court accept for keeping the rest private? That is the issue now sitting before the judge. Now let's bring Atiku Abubakar into this, because this is where the story becomes political. Atiku has now publicly challenged the FBI's argument that releasing some of the records could really endanger lives. And his argument is actually more specific than simply saying, release everything. Atiku said the FBI should protect its agents' sources and legitimate investigative methods. But if there is information that can legally be released without compromising those things, Atiku wants that information made publicly by all means. As usual, his argument is that concerns about protecting lives should not become a blanket excuse for keeping everything hidden from public scrutiny. And he connected that argument to what he says Nigerians are already experiencing under Tinubu's administration. He pointed to insecurity, hardship, food prices, healthcare, and the effects of fuel subsidy removal. His basic argument is, if information can legally be released about the person occupying Nigeria's highest political office, Nigerians should have access to it. And this is where Atiku's political interest in the matter becomes impossible to ignore. Because Atiku is not simply a former vice president anymore, he is also the presidential candidate of the ADC ending into the 2027 election. And public accountability surrounding the incumbent president is obviously going to become part of the political conversation. It is also worth noting that the Washington lobbying firm that publicized the FBI filing has been hired by Atiku. So while Atiku did not originate the underlying FOIA lawsuit, his political camp is now actively pushing the transparency argument around the case. And this is probably the most important part of the entire video, because once the FBI used words like endanger life and asked to explain itself privately, different interpretations immediately started appearing. On one side, We have some commentators asking whose life is supposedly at risk. Others are asking whether the records contain information about confidential sources. And some commentators have gone so much further, suggesting that the language could indicate something much more serious. And I'm very sure by now you have probably already seen some of those claims. But here's the problem. A theory is not the same thing as a court finding. For example, some people have suggested that the records could somehow establish that Tinubu acted as an informant. That has not been established by a US court. The FBI has not publicly confirmed that claim, and we should not turn speculation into facts simply because the circumstances are mysterious. The mystery is real, the legal dispute is real, and the FBI's request for private review is also real. But the conclusion people are drawing from that request is where we have to slow down. David Ondeyin has also offered a much more aggressive interpretation of what the FBI's position could mean. And his argument is essentially that if the FBI says it cannot even publicly explain why certain records are being withheld, that could suggest the material involves something much more sensitive than an ordinary old civil case. He has also gone as far as arguing that the matter could involve intelligence concerns and that the public is being distracted from what he considers the real significance of the FBI's filing. But again, like I said, this is some interpretation. It is not a finding by Judge Howell, and it is not a public statement from the FBI saying Tinubu was an intelligence asset. Those are claims and theories that should be understood as much. And honestly, that distinction makes the story even more interesting because we don't actually know what the judge is going to see. The FBI says some of the information is too sensitive to explain publicly, and the judge has now agreed to look at the confidential explanation. So, the person who may know more about what is actually inside those records than almost anybody else right now is the judge sitting on this case. There are several possibilities. The judge could decide that some of the FBI's reasons for withholding information are legally valid, and in that case, certain records or portion of records could remain protected. The judge could also determine that some information does not qualify for protection and should be released, or we could see a mixture of both. Some documents could become public, while sensitive names, sources, methods of other protected information are redacted. And that is why the August 28th deadline matters. And I guess at this point, that is one of the reasons why you should subscribe and turn on your notifications so you don't miss what happens next. Because this is another step in the legal process. It is not automatically the day Nigerians will receive the entire Tinubu FBI file. That is a very important distinction. And now we come to the bigger political picture. This story is no longer just about an old American investigation. It has become part of the political battle surrounding Nigeria's 2027 presidential election. Atiku is asking for greater disclosure. Tinubu remains the city president and the leading figure of the ruling APC, and every development involving the president's past, his record, and questions surrounding his credibility is likely to become political ammunition as the election approaches. But Nigerians also have to separate politics from evidence. If the US court eventually orders the release of information, people will have the opportunity to examine what those documents actually say. And if the court keeps some information sealed, there should also be a legal explanation for why that information qualifies for protection. That is how a serious legal process is supposed to work, not through social media rumors, not through political propaganda, and not simply because one politician says one thing and another politician says something else. So right now, the biggest takeaway is this: the Tinubu FBI records have not suddenly been released, but the case has taken another major step. The FBI has been allowed to explain privately to Judge Beryl Howell why it believes some of the records should remain protected. An article is demanding that whatever can legally be disclosed should be made publicly. And commentators on the other side are already debating what the FBI's language could mean. But until the court actually rules on the document, we have to be careful about filling in the blanks ourselves, because there's a huge difference between what the FBI said, what the court allowed, what article is demanding, and what people are speculating about. And that difference is exactly why this story deserves to be followed closely. Because if the court eventually orders the release of significant portions of these records, Nigeria could finally get more information about a controversy that has followed Tinubu for decades. And if the court decide that some of the material must remain sealed, the reason for that decision should become just as important. So the next stage is not about social media or whatever. It is about what the judge sees, what the law allows her to release, and what happens before and after that August 28th deadline. And as we move closer to 2027, you can expect this story to become even more political. So I want to hear from you. Do you think information concerning a sitting Nigerian president that can legally be released by US authorities should be made public? Or should sensitive FBI information remain protected regardless of the political consequences? Let me know what you think in the comments. And if you want me to keep breaking down these 2027 political developments without the unnecessary noise, just the facts, the claims, and what they actually mean, make sure you subscribe because this story is not over yet.